Hello everyone, welcome back to the channel where we discuss the complexities of law, especially those that impact businesses and commercial entities in Singapore. Today we are going to examine a recent and insightful case about contract formation, back-to-back trading practices, and the nuances that can make or break a commercial contract. Our focus today is the case of ISU specialty in the Singapore High Court. We will dissect the judgment, analyze the main arguments, and provide a commentary on the legal principles highlighted. Let's start with a bit of context. The case revolves around two companies engaged in the trade of light cycle oil. The claimant, ISU, is a South Korean company acting as a middleman in the oil industry, facilitating deals between refineries and end buyers. The central dispute arose from an alleged contract for 300,000 barrels of light cycle oil, known as the March cargo. ISU claims that through a series of discussions and agreements, a binding contract was formed with C&D. However, C&D denies this, asserting that no final agreement was made. This case is important because it delves into whether contract terms discussed informally, often in real time through messaging and calls, can bind parties legally. The main legal question is whether a contract for the March cargo was indeed formed between ISU and C&D. According to ISU, their representative, John Woo, and C&D's representative, Jason Kerr, agreed on a deal for the March cargo during two phone calls on 2nd of February 2021. ISU claims the terms discussed were enough to establish a binding contract, specifically an agreement to purchase at a cost, insurance and freight price of USD 850 per barrel above the means of plat Singapore index for March. However, C&D argues otherwise. They maintain that they had not committed to any purchase and contend that the March cargo was discussed only as a possibility, with no final terms or agreement. According to C&D, Jason Kerr explicitly told John Woo that C&D could not discuss or confirm any purchase until after the Chinese Spring Festival, and that all deals required email confirmation to be valid. The judge, Chu Han Teck, meticulously reviewed the exchanges and industry practices. Here's a breakdown of his findings. First, he noted the industry's practice of back-to-back trading. ISU's business model involved back-to-back trades, where they only proceed with a refinery purchase after securing a buyer. This arrangement is common in volatile oil markets, where a middleman's profit depends on quickly matching buyers and suppliers. Next, Justice Chu found that both parties understood the necessity for swift agreements in the light cycle oil industry. Given ISU and C&D's prior dealings, it was likely that ISU acted in good faith, expecting C&D's commitment. A significant point the judge noted was C&D's failure to dispute the deal recap email sent by ISU on multiple occasions. In similar cases, courts have inferred the existence of an agreement if a party fails to respond promptly to such recaps. The judge also took into account the impact of market conditions. C&D argued that the falling price of light cycle oil and internal policies should prevent them from committing to the March cargo. However, the judge noted that despite unfavorable market conditions, C&D had actively participated in similar deals in the past. As a result of C&D's repudiation of the contract, ISU incurred significant financial losses. The court ordered C&D to compensate ISU for these damages of approximately USD 1.6 million. Let's unpack the legal implications of this case and discuss its broader impact on Singapore's commercial and contract law. This case reinforces that contractual agreements in high-stakes industries don't always need formal documentation. In certain industries where transactions occur rapidly, agreements can be formed via phone calls or messaging apps. For businesses, this ruling signals the importance of clear and documented communications, especially when discussing terms. Failing to formally object to a recap, as seen here, can be interpreted as acceptance. Back-to-back trading practices and the need for immediate responses play a crucial role in this case. The court acknowledged the industry standard for middlemen to operate with minimal market risk, which necessitates a near simultaneous agreements with buyers and sellers. This principle underlines that Singapore's courts will consider industry practices and commercial realities when determining the formation of a contract. This case may impact future commercial disputes, especially in sectors like oil, commodities, or finance, where timing is critical. Companies engaged in back-to-back trading should be mindful that failing to challenge an agreement or delaying a response could be viewed as acceptance. Moreover, if companies require additional approval steps such as written confirmations or managerial consent, these terms should be explicitly stated in their contracts from the outset. To sum up, the case of ISU Specialty Chemical serves as a reminder that the law is sensitive to industry practices. In this instance, the court recognized the significance of real-time decision-making in the volatile light cycle oil market. For businesses, the lesson is clear. Always communicate intentions clearly and document agreements thoroughly, especially if industry practices favor swift and informal transactions. Thank you for watching. Don't forget to like, share, and subscribe, and hit the bell for more insights. Until next time, stay informed and keep navigating the law wisely.